So a lot of us have self-censored ourselves because of what has been going on. You're not sure what is going to happen if you say something. And there is always the joke of utakujiwa. And we have started taking it very casually. And I think I want to talk about an experience. I may look young, but I'm not. I actually grew up in the Nyayo era. He was saying he thought I'm a very old person, but it's the look. I'm old. I grew up in the Nyayo era, and one of the key things I remember is we couldn't just say anything in public. You had to measure your tone, measure the things you said. And when we say we're going back to the Nyayo era, is because we feel like we are going back where we were being censored in what we could say, who we could associate with. And for me, I feel it particularly because in the Nyayo era, my uncle was one of the Kenya people who fled the country. And when he fled, they came for my father, for him to tell them where my uncle was. So I have felt it personally that even sometimes you're not the one speaking out, but the people you love can be picked up and asked where you are. So my dad spent a day in Nyayo and being asked very many questions. And even my mom was called to be asked where my dad was. And when she was called, those days it was telephone calls, no mobile phone. So when she was called and told there are people who are looking to talk to her, she immediately called our neighbor and told the neighbor, my kids are coming home. If I don't come home today, watch out for my kids. But they just asked her where my dad was, they picked my dad. So for me, it is a personal experience of how it feels to know that something you say could affect you or the people you love. And I don't want us to go back there. A lot of people who are living here has experienced it. His family has experienced how it is for them not to know where he is, just for him stating something that's common sense. So we need to make sure that all the laws that are unjust are removed, are not passed. And because sometimes they take your freedom a little. Then one day you find you have no rights at all. So we need to keep fighting. And I am so proud of BAKE, that BAKE continues to be in the space and continues not just to look out for content creators, but all the people, so that we can be able to tweet freely. We can be able to do that video without thinking about the repercussions. So now, I will start with a quote as I start the statement from BAKE. Martin Luther King says, "In the end, we will remember not the words of our enemies, but the silence of our friends." Let us all collectively work to make sure that we all have freedom of speech. You may have freedom today and think that it's okay when some people don't have freedom, but one day that freedom that you particularly like, they will come for it and there will be no one to speak for you. So the statement from BAKE. For years, we at BAKE have argued that Section 22 and 23 of the Cybercrimes Act were nothing more than an unguided missile designed to silence dissent under the guise of fighting fake news. Today we celebrate the Court of Appeal that they agreed to strike down these sections. The court has recognized that truth is not a monopoly of the state. It has protected the whistleblowers, the people who do satire, and everyday Kenyans who share information in good faith. This is a massive win for free speech. No longer can a content creator face 10 years in prison for a post that discredits a reputation or causes panic. That era of discrimination against or criminalizing the truth is by the stroke of a pen over. However, as we celebrate, we must remain vigilant. The court's decision to uphold surveillance powers, even under vigilant judicial oversight, remains a concern. We have seen how these powers have been used in the past to target the very people in this room, or the people that they love. While the courts have tasked our judges to be the gatekeepers of our privacy, we, the digital community, must be watchdogs of these gatekeepers. We also note the retention of Section 27 of cyber harassment. When we advocate for a safer internet, we worry about the subjectivity of what is grossly offensive. Our next steps are clear. 1. We call upon the Office of the Director of Public Prosecutions to immediately drop all pending charges against Kenyans currently prosecuted under the now unconstitutional Section 22 and 23. 2. We will continue to educate our members through our Moral Digital Rights Initiative. 3. We are regrouping with our partners to evaluate an appeal to the Supreme Court on the issues of privacy and Section 27. The fight for a free, open, and secure digital Kenya is not over, but today we breathe a little easier. As our lawyer, Mercy Mutemi, said, this is a pivotal moment. Let us use this momentum to ensure that the law serves the people and not the other way around. Thank you.
I think the lesson that I think from it is the value of strategy. We might not have been entirely strategic at the beginning. I say we meaning everyone who's touched the case one way or another. Because I did at the High Court and at the Court of Appeals. On behalf of the LSK and the Kenya Union of Journalists, we went before Conservative Judge Justice Makau, and we asked him to clarify, amongst others, the provision on child pornography. I don't know if he had decided Rafiki by then or not. I'm not so sure, I don't remember, but he made the same decision in Rafiki. And so maybe a more strategic move then would have been to panel, for example. I was saying that reflecting, if I went back and researched in a strategy meeting, I'd do it differently. We asked Justice Makau, an old judge with about a year to retire, a year or two, a conservative judge, to nullify the entire act, which amended everything the act, including the provision on child pornography. Maybe if we focus on sections 22, 23, and 27, and maybe one or two others, we might have got a different outcome, just looking back. Because the exact replica of those sections had been nullified. Nalai, Nyakundi 1, Nyakundi 2, I think Nyakundi 3, Kinandare, as far back as 2015, 2016. So, as I've had the plans to go to the Supreme Court, I think there's need for strategy. Just look at the decision, read it, see which is the most harmful for us. Even the Court of Appeal, we nearly made that same mistake. We went in with 48 grounds of appeal. At the Court of Appeal, usually 6 is okay, 6 grounds of appeal, 5. In fact, the court itself narrowed them down to 6. usually about 6. When you go to the Supreme Court, it's 1 or 2 issues of law, pure issues of law. Facts are now there in the first court and the second court. So there's need for strategy to craft the prayers with precision, to argue really narrow grounds, extremely narrow, that can persuade the court so that the outcome that the bloggers community is looking for, they can get. I think that there's been a lot of delay in this case. If the decision came out that maybe Albert should not have died, because he was arrested under that act. And the people I think who've fallen through the cracks, arrested over the years, since Macau's decision back in 2020, 6 years of enforcement of this act. I don't know what we could have done about that aspect of delay. Those are my reflections for now.
How long has it taken, this whole process, how long has it taken?
The High Court petition was filed in 2018. This being presidency, so 8 years. Yeah, we have maybe 1 or 2. The Supreme Court hears its cases within a year. So if you file now, you could be heard in the final court of the year, around October or November. If it goes, if it delays, maybe early next year. But around October, November, it should be heard as well. Thank you.
Thank you. One more question. We have the 2 major sections. We have section 22 of false publications. So this section criminalizes the intentional publication of false or misleading data. Section 23, publication of false information. This section criminalizes the publication of fake news that results into panic, chaos, or discredits reputation. They are struck down because they were too broad, and the judge noted that what is false today might be true tomorrow, of course. And then the court noted that the National Cohesion and Integration Act and the civil defamation laws already handle these issues without needing such harsh criminal sanctions. So I think they were giving 10 years and some quite a few millions. But this is what the court upheld, which still remains law, and which I think we also now discuss today and move forward. The court disagreed with BIG on several other points, keeping the following powers and sections intact. Number 1, sections 48 to 53, investigative powers and privacy. The court ruled that the police can still apply for search warrants for computer data, production orders to compel service providers to give up subscriber information, real-time collection of data, that is surveillance up to 6 months. The judges argued that these are not unchecked powers because they require a court warrant, so that is something we'll have to talk about. They emphasized that judges must be gatekeepers to ensure the police don't abuse these tools for political reasons. Then number 2, the guilty minds. They argued the law was vague about who is a criminal. The court ruled the terms like knowingly, intentionally, and without authorization are sufficient. If you accidentally stumble into a file, you're not a criminal under this act. You must have intended to break the law. Then we have section 24, which is child pornography. The court upheld the strict penalties for child pornography, dismissing the technical argument that the wording would still be used to target adult content unfairly. The legitimate aim of protecting children outweighed the privacy concerns raised. So that was upheld. Then section 28 was also upheld, cyber-squatting. Using someone else's name or trademark as a domain name in bad faith remains a crime. The court ruled that the internet is not a wild west and property rights must be protected. So we'll also talk about the key takeaways for content creators and journalists. But let's hear from Mobili.
So there's also 27, harassment. That was upheld. No, cyber harassment, 27 as well.
Okay.
I have a court case, but I have not been charged. So they made an application, the DCI made an application through the PPP, and they used that false publication clause to basically now go after my gadgets. So even though I have not been charged yet. There's an application. They have my phone, yes. So maybe the only way I can tell the story is I can tell it the way Rahab started with her uncle being in the Kenya movement. So just a minute, let me silence my phone. So I have no idea what I am doing here, Rahab. So yeah, I have no reason to be sitting in this chair today. And no Kenyan should be in such a position whereby you find yourself you are wanted like a terrorist by the government. Because my abduction operation was so big. I was not abducted in Kenya, I was abducted in Dar es Salaam. And it's actually today morning when I started remembering, like after these guys captured me and they started going up to my identification and they were being shocked, like they were expecting this bearded, kitamba, hiding, and I don't know what kind of profiles they're given about people on social media who speak out against the government or whatever. So that was the shocking part, because they were 100% guaranteed that this is a terrorist and they cannot let go, let's say, they cannot even believe their eyes, So being given that privilege by your government, by the president, is super mind-boggling. So, Commander, it's the experience, and then after the abduction, I came back home, and then I said, okay, Sasahibo, because I don't even know what I am. We have interacted with me before July 2020 on Twitter. And there was a Twitter troll. I went on Twitter, wasted my days. It was allowable for me to go let out my frustrations. It was not a place for me to make a political opinion. But then when it became an adult, I started running a company, and then the government action directly started impacting me, and then that is how I turned political before 2022. I campaigned for Ruto, I voted for Ruto, I protected his vote in my village road. So, yeah, so to see now the things he was saying, he was going to do CG Kenya business, and then he turned around immediately. So, I just started voicing my frustration against his government, and then I became a terrorist. Now I'm here sitting here discussing a law that is used to persecute me and my family. So it's mind-boggling, really.
Thank you so much for that. I think as we go on, we'll understand now how also we balance the digital regulations and the freedom of speech that you're talking about. I think we'll give a representative from ICJ, which is...
Okay, let's say at this point in life, in the Kenya we are in, everything is a sensitive topic, from corruption to health. Anyone who comes forward to speak on these topics, it's viewed as dissent. So if journalists themselves are afraid to air this content, then the freedom of speech is actually quelled without even lifting a finger. These laws are aimed at protecting people, but if you look at the way the sword swings the other way, it also kills the freedom of expression in the long run. So we applaud the court for taking especially the Court of Appeal. It's not so much for going the other way, but we applaud it for at least the Section 22 and Section 21, but still, there's still a long way to go. And these vague laws, I think, is what has gotten us into so much trouble lately. Sometimes these laws just don't actually specify who they're targeting or what they aim to target. So sometimes, in as much as ni kama wanasema shika, for now chicane as we wait for the 2027 elections, because there's nothing much that can be done in this period between now and 2027. We'll have to wait for another election cycle, another leadership for things to actually start taking point. And in the meantime, journalists will be self-censoring, people will be self-censoring, people will keep on being arrested. And as we work also on our other projects, we saw that people were arrested last year and charged with the crime of treason. The crime of treason in Kenya attracts the death penalty. The death penalty which is not abolished in Kenya. So what stops these people from being executed? So sometimes this right of speech also moves into the right of life, the right to health. It's one that plays with all our other rights in the Constitution. Thank you.
So I feel like we should not be afraid to post on social media, because even in the Constitution, we are allowed to express ourselves. So I think the key point is looking at media edits, being aware that we have label, we have slander, and also fact-checking, sorry. So I think we should not be afraid.
I will start by saying I felt, in my opinion, the court did not really put a lot of weight on the privacy elements. Yes, as Kenyan citizens, we have a right to privacy, including to having the right of our communications not being infringed, which is very ironic when we read the judgment. And in one of the sections that were upheld, there was one, I think it was section 53, that was providing for the interception of communications, including private communications. And in the judgment, one of the reasoning was the court found that there were actually procedures that were put in place to govern how Section 53 would be working. But when you're, and the reasoning they said, the magistrates mentioned that provided there's a court order, but to what extent, what are the limits of this particular section? They did not go further to explain how are these police officers going to be governed, what were the procedures that needed to be put in place when you're submitting court records, or when you're asking, you've abducted someone, or you've actually arrested them according to the due procedure. What procedure is going to be put in place to make sure that you only collect what is necessary? Of course, we have seen time and time again through the abductions, how they confiscate everything. There's lack of transparency. They're not telling the victims that we are going to check. What exactly are we going to check? And even going to the extent of using softwares that are known to actually swipe off or review everything that is on the device. So it was not really convincing. The court needed to have actually put in place guidelines. You need to be transparent to the alleged perpetrator, which type of data you're going to go through, whom it will be shared with. And even after the investigation, you need to put in place retention periods. How long are we going to keep this information for? You've already done your investigation, but you need to delete that data. Again, it was not also very clear. But my biggest concern is how government agencies are, what's the right word? They are culprits of taking information for one purpose and using it for another different purpose without the consent and even without the knowledge of the individual. Then again, we've seen how information is misused for political purposes. So they needed to really consider those few factors. Again, you've abducted one individual, but it puts at risk an entire family or even an entire community. You're not protecting the data of these third parties. As both our panelists were saying, one person being arrested, it means the family members will also be contacted to provide information to which they didn't even have, they were not privy to. Because me, I'm related to an activist, it doesn't mean I know what they're actually planning. So the government really needs to implement the issues of confidentiality, which the court seems to keep on missing. And again, that is why you find that when lawmakers are making laws, they're not having privacy first as an option or as a priority.
Thank you so much. I think I will ask a question later based on that, because sometimes when someone is abducted and they post, the first thing we always think of, this is the police posting, not them. So they've confiscated all your computers and your laptops and your phones, then they can use it however they want. So I think we'll come back to that. Jamie. So Jamie, you will speak on the judgment and its repercussions on the region, and especially other African countries dealing with the same issues. We know we are not like the only ones around, especially East Africa. What are the repercussions?
Yeah, I think like the judgment, especially on the sections that were struck down, are very significant in terms of the regulation of freedom of expression regionally, especially with last year from the Africa Commission on Human and People's Rights with Resolution 630, which provides the Special Rapporteur on Freedom of Expression with the mandate to create guidelines for states on monitoring the performance of platforms, social media platforms, and tech companies when it comes to regulating information integrity online. So that regulation of information integrity would be relevant, especially to these provisions on misinformation and disinformation that was struck out, because it provides like a guidance on that balance in how to engage with freedom of expression during an age of information disorder online. So I think it would be really relevant for that, because as the other panelists have mentioned, we've also seen situations where a lot of the lawmakers in our countries just learn from each other in the very bad legislations or provisions that they include on internet regulation. So this provision also has very positive repercussions in that it could guide other courts when similar legislations are challenged in local courts, but also in regional courts. Like we've had very positive cases with the ECOWAS court, for example, when it comes to their findings on internet shutdowns, which have been really positive in creating good jurisprudence on that. So I think this does the same thing in helping guide those kinds of decisive decisions, because we've seen that the track that a lot of lawmakers have taken in other countries is similar to ours, where they'll put a lot of these provisions on cyber-enabled offenses in cybersecurity or cybercrime legislations to restrict speech that they don't like. So we've seen this in countries like Zambia, in Tanzania, in Nigeria, for example. And now in Ghana recently, we have what will be one of the first very expansive internet regulations on freedom of expression, which is the Misinformation, Hate Speech, Disinformation, and Other Information Bill, which has very expansive provisions on freedom of expression. So there are provisions, for example, on misinformation to government agencies or government officials, public officials, private entities, private individuals. So you see, like, it's very, very expansive, and it has all of these very broad provisions, because even in deciding what is false information, they are never really able to provide provisions that are not very broad or cannot be misused. So I think the court's decision in this case is a very good example as far as the freedom of expression sections of it. But I would agree with the previous speaker when it comes to the other sections on the right to privacy. Those are still very, very concerning, because a lot of our government and other governments in the region have taken like a securitization first approach to internet regulation, and then human rights are just not even a thought in their mind. So we have a lot of these securitization like provisions, but then Kenya has like a business and human rights framework, but we don't have a business and human rights law. So in like what the previous speaker mentioned, when we have these gaps in transparency where we know that we will not get information from authorities about their procedure in interception or requesting for subscriber information through production orders, like if they're serving them to telecommunication companies, for example. But these telecommunication companies do have human rights policies, but unfortunately, transparency is not like, there's no legal law in Kenya that mandates these companies to report transparently on those kinds of things. So I think that also now creates a gap that is a danger. So the guidelines that the Africa Commission on Human and People Rights will provide probably this year on information integrity could be a guide to that. Because what we've also seen in other countries, which we don't have in our Cybercrimes Act, which is a good thing, but where they also now start encroaching on intermediary liability. So this is where, like, for example, tech companies are being held liable for the content that third parties are posting online. So they'll say that if you don't take steps to mitigate false information being posted on your platform, then you will also be held criminally liable for what users on your platform are posting now, which will incentivize platforms to censor people, which will also incentivize people to limit their own speech with self-censorship, which we don't want. So I think even though we are more broadly disappointed with the decision that the court has made, striking down those two at least is a good step. I would have liked also to see cyber harassment being struck down, because that now is also something that can be broadly interpreted for the government to say, you know, if it's up to them to decide what harassment is, then they have a lot of leeway to decide that. So that's still a bit dangerous. But I do think it's a good step, and I hope that it's a decision that will guide other lawmakers in countries that don't have regulation on freedom of expression online yet, in what that can look like in terms of it should not be too broad, and it should not create a chilling effect.
Thank you so much, Jamie. I think the next one, I was just remembering, I don't know if we bullied or we trolled the previous president, and the only thing he did is leaving the platform. Like, he didn't come with all these all days where you just chongwa the president and he just leaves the platform. So we'll hear from Mudoki, and then and she'll talk to us about the ramifications of the judgment on journalists. Now I wanted to ask if it's just journalists, because journalists are guided by a code, or it will be journalists and bloggers, because some of us, when we report something, you label a journalist. So talk to us about journalists, and then maybe someone else will talk about bloggers and content creators.
Thank you very much. If you don't know it, while her comments are still fresh in mind, I would just like to expand, hopefully not repeat. So the regional ramifications, I think, cannot be emphasized enough. And I think what she said about legislators learning, we tend to see it in real time, because you get Angola, I think, is considering a new cybersecurity law that is a baby of a fake news law. And right now there's the litigation against the Zambia law. You see echoes of our law in all these places. Maybe not a copy-paste, but you definitely see the echoes. And in more informal engagements, you hear Kenya referenced repeatedly. So what happens in court here does actually matter. And for instance, in the Zambia litigation that's happening, I was looking at some of the amicus briefs, and they reference precedent in Kenya around kicker. So you can see how precedent in Kenya around our own CMCA might also be incredibly useful. So the battle we're fighting here is really a battle that goes well beyond our borders. Now, in terms of ramifications on journalists, thank you for asking me, is this just journalists? Because they have a code of conduct that's really good, because it problematizes a debate that we have continuously, and which I think I've sometimes bothered Wamathai about, who's a journalist? And we like to, I think I've said it so many times now that it's a little bit of a cliche, but we like to not say who's a journalist, but say what is journalism, which recognizes that even, and the example I always give, a pastor who writes a column can be argued to be committing an act of journalism. A blogger can also commit acts of journalism. So it's about the product as opposed to for us at least, do you have accreditation, or have you worked at an established media house? So when I talk about ramifications, for me, I'm thinking broadly about this, broadly, flexibly defined community of people who commit acts of journalism that should be protected. Now, I don't want to repeat a lot. The 22-23 being found unconstitutional is incredibly profound, because we know that when someone doesn't like the investigative journalism you've been doing into their corruption, the easiest thing to do is to accuse you of quote-unquote fake news. And we've seen that globally. So we keep track of journalists who are detained, or people who commit acts of journalism who are detained. And we've seen over the last, I want to say, almost decade, that there's a rise. Previously, it was terrorism that was used a lot as pretext to throw people behind bars for acts of journalism. Increasingly, it's false news, it's fake news. Who's defining that? So that being declared unconstitutional, the profound impact cannot be overstated. However, and I'm going to repeat what she said, the fact that all these other sections remain untouched, almost upheld, is deeply problematic, because the segment that we've seen actually being used against journalists or people trying to do journalism a lot is cyber harassment. You do your story, you reach out for the right of reply, which is journalistic conduct. You mentioned the code of conduct. You must seek the right of reply. And by sending that message to say to someone, hey, you've been accused of ABCD, do you want to comment? This is equated to an act of harassment. Reaching out to people to get them to comment on stories, or to get their perspective on things is equated to an act of harassment. And we can see how easily it will be to just shift from 22-23 to use 27. We've already seen being used. I fear that it's going to be used a lot more. And it is, again, a tactic that goes well beyond Kenya. I think Uganda has frequently journalists arrested for harassing the president, and bloggers arrested for harassing the president. And it's just a tactic that I fear we're going to see more and more of. And of course, the surveillance, the privacy implications, when you consider that you're dealing with a community that is required, again, by its code of conduct, to protect sources, to protect whistleblowers, you can see how those sections remaining as they are is still problematic for people committing acts of journalism. I don't know if I've answered your question.
Yes, you have. And I think if anyone has a comment or a question, you can just wait for like 5-10 minutes as our next speaker. Yes, I think we'll hear the ramifications. I'm looking at the next speaker. Eric Odbor. Yes, you can briefly tell us the ramifications of this judgment to bloggers, and also, now that we talk about bloggers, just add a bit of social media users, because at this rate, all of us who are on social media are co-bloggers. So you can just talk to us about it for like 5 minutes. Then we'll open the floor for everyone who has a comment before our next speakers. Thank you.
Okay, thank you. My name is Eric Odwar, Secretary General for Kenya Union of Journalists. We are one of the parties in this case. One, I think, as much as we had gone there to look for more, the two sections that were actually the biggest, that were being used mostly by security people, were actually declared unconstitutional. That is 22 and 23. And from the beginning, when this law was enacted the first time in 2018, we did raise our issues about the two sections, because this law is largely a security law. It is not a media-related law. I think we need to get that distinction. That the Computer Misuse and Cybercrime Act is largely a security law, not a media-related law. And if you look at how it is operationalized and how it is implemented, it is largely implemented by security people. That committee, look at the composition of that committee. So when they sit there, what they go in and like for what my sister was talking about, it's all about securitization of the whole issue. Let us bear in mind that when these guys go there, they are going there with the mind of protecting security of a country. That is why the composition was the IGPS in charge of security, NIS director. You see, all these guys, when they sit there, they are looking at discussing security. But the fact that the court saved us from those two sections which were abused by the state, that is a big win for us as journalists and even the bloggers or anybody who consumes social media or digital products. It's a big win for us, because if these guys sit there, all of them going in this meeting with a security mind, definitely they will always declare everything false. And we were arguing that who has got this instrument that they'll be using to test whether information is false or not, because we know that we are living in a country where deny, 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 deny. I'm sure they usually use that men, that even if you are caught pants down somewhere, but the rule is deny, deny, deny. And exactly that's what the government is all about. You write a story about what is going on, the rule within the government is deny, deny, deny. So the information is accurate and factual. Definitely from the state point of view, they will always say that that information is false. So the fact that we were able to get those two sections declared unconstitutional, I think that is a big win for everybody in Kenya, everybody who uses social media and even journalists. Because if you look at some of the charges that have been preferred on several people who have been arrested for social media use, they have always used these two sections. Contrary to section 22, contrary to section 23, you publish blah, 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 blah on X or on Facebook or on Instagram. So I think ramification is that, number one, we were not able to get all that we had prayed for in this case, but something to celebrate is there that the two sections that have been used mostly by security agents to persecute Kenyans actually have been declared unconstitutional. So we are looking forward to see which sections are they going to use. And we knew very well that from the beginning, even at the High Court, the judge did not agree with us, but I'm sure even from where that judge sits, he knew that that decision was wrong. So we believe that this Court of Appeal judgment is going to stand, and the state will not be seeking to maybe probably move to the Supreme Court, because we are living in a country where we know that anything can change at any time through a phone call. So for now, let us celebrate the gains that we have and also to continue to fight to protect human rights, freedom of expression, and access to information. Thank you.
Thank you so much. A round of applause, I think, for the speakers who have spoken so far. I'll give 10 minutes to somebody who had a burning question or a comment. And then we'll also need to hear from the tech side, from the civil societies, like how this law, how this ruling has affected us so far. So I think the mic, you can pass the mic.
These acts that are implemented are unconstitutional, just like Article 22 and 23. They were declared unconstitutional because they were over-restricting expression, and it was quantitatively affecting the content creators. And once again, I just would want to say that, okay, when we now narrow down to matters politics and national administration, you cannot silence awoken youth. I mean, not even the youth, but generally Kenyans have opened their eyes. They have demonstrated that indeed they do not want this regime on board, and that restricting or limiting expression can only spark defiance and rebellion. I mean, why can't people? The other day we were having PDF, but what was the uh, a very figurative framework on how PDF could be conducted, because even the Constitution does not outline how public participation should be done. Because even in such a setup, if I can just pick someone and ask them, what is your opinion regarding this Cybercrime Act? And they tell me I fully support it, and someone tells me that, and somebody else tells me that it's impunitive, it's controversial. I mean, I can go with that report and say, I conducted a public participation. So I guess the Constitution also should have an adjustment and maybe explain how public participation should be conducted. And also, when it comes to restriction on what people, there's so many of us, like there's a time a lady asked, how many of you have ever had that very I don't know, let me just not say uncouth, or just something that you just want, that has been used to provoke you, and indeed you want to tweet or retweet, but you type and type and type and type, and just before you send it, now you delete everything and you're like, let me just absorb it, So I guess now we are now readjusting the Constitution intentionally. I mean, if the Constitution clearly outlines that there should be freedom of expression, freedom of expression, then, I mean, let it be exercised, and let us just be mindful and thoughtful of what we are going to be posting on social media, because there's a day I was a participant in PDF, and there was a lady who actually stood and expressed the kind of frustration she has gone through the tweets these young people tweet, and she's a parent and she's an aspirant. She's like, I didn't expect that from maybe my children, and so sometimes we as Kenyans, let us be mindful of what we post on social media, because it can hurt someone's feelings, knowingly or even unknowingly. Thank you.
So, as mentioned, each speaker will help us unpack this judgment from different dimensions. So, I want to hear from Miriam about the ramifications on civil society. We know the civil society has been with this case for so long. So, tell us what you feel about the law, and way forward. Thank you.
All right, thank you very much. My name is Miriam Beatrice Wanjiru. I work with Paradigm Initiative as the Programs Officer for East Africa. I also sit in the steering committee of the National Coalition on Freedom of Expression and Content Moderation, a mouthful. Lovely to be here. I wasn't one of the panelists, but my immediate reaction to the first question that you asked, my immediate reaction was in part excitement and in part worry. Excitement because I know this has been ongoing for a very long time, almost a decade now. I think 8-9 years. So kudos to you guys. ICJ, Article 19, BEC, you've made us all proud. It's no mean feat to have the two sections declared unconstitutional. The other part, worry, because as you would remember, 26 sections of this particular act were challenged and only 2 were declared unconstitutional. So it means we are definitely not there yet. And I'm looking forward to the discussions, particularly from Mercy and the team that has been leading this process to see what next. If I am just to give my humble recommendations, we definitely need to go to the Supreme Court and fight for the other 24 sections. Your other question was as a civil society organization. So that, no, I think it's a really, really good thing, because we've seen hundreds, if not thousands of people fall prey to this particular act, from journalists. And I think there are people who are still arrested and in prison, and they were charged based on this particular act. So when it comes to freedom of expression, freedom of the media, it's something that we are really excited to see that, the judiciary upheld and reaffirmed what we already know, that number one, we are a constitutional democracy for a reason. And this act was going in contradiction, was a complete contradiction of for example, Article 33, which speaks to the freedom of expression. So it's refreshing for once to celebrate and see that, particularly the judiciary agrees with what we fight for every day. Human rights, digital rights, freedom of expression, freedom of the media. There are still issues around privacy that we need to be very worried. I'm also looking forward to the speakers when they'll be engaging on how far the case has gone, and people like Dudley regarding the amended version, Computer Misuse and Cybercrimes Act 2024, that was assented into law last year. Last I checked, there were conservatory orders, but I'm curious to see how far we've gone. So really happy to be here. Thank you.
Thank you. So I want to ask this question. I think now that we're going to the elections, after the next speaker, I think we will go to that. Like, what are our fears when it comes to freedom of speech? As she said, we need to tone down on social media. What do others feel? So as we move forward, before ICJ now comes and tells us, you can post whatever you want with confidence, with your chest. We'll be there to support you. We'll be there to bail you out. What are all our thoughts? So we'll give our... Sorry? Okay. Understand there was a question that was asked on the technology-assisted GBV. She had mentioned that when you see a community tweeting about this, there's going to be a problem. So I think Miriam will cover that. Yeah. Now, as everyone in the room thinks about the elections and freedom of speech, as we wait for the other speakers.
Okay, so I think your question was broad on we seem not to be doing enough when it comes to technology-facilitated gender-based violence. I tend to agree with you. There is definitely more we can do. So just my initial remarks that technology-facilitated gender-based violence is a global phenomenon. It's not just unique to Kenya or Africa, it's a global phenomenon, but we are seeing it expand and become more sophisticated. Of course, as we advance in technological innovation, we're also seeing a rise of technology-facilitated gender-based violence. However, this is not just an emerging issue. It correlates with drivers that have always been there, things like misogyny, things like political intolerance, things like just the bad behavior, I should say, that has always been there is now translating into the online space, and it's a huge factor. Speaking from a policy angle, and I know we keep saying we have so many laws, but I think the fact that we don't have one sort of legislation that speaks to technology-facilitated gender-based violence in and of itself is a gap, because how do you go and claim that your rights have been violated? What are you using to back it? So that in and of itself is one of the gaps. At this point, allow me to also mention that as an organization, one of the things we are doing is, number one, accepting that and recognizing that it's a violation, and it's a violation of digital rights and human rights. And through our reporting platform, Reporty, in case there are any technology-facilitated gender-based violence, either you are a victim or a survivor, please report. We'll help you go to court pro bono, or help you, get you in touch with the right people who can support, either psychology experts. So it's something that we are taking very, very seriously. And just to agree with you in a lot of many words and a lot of English, agreeing with you that yes, there is indeed a problem and we need to look into it.
Thank you, Miriam. Yes. We can just pass the mic. We love hearing pro bono, so we'll share your numbers, because next year we'll need a lot of pro bono services from all of you.
Okay, so the question has actually been adequately answered. I'm just going to problematize it a little bit, because one of the things we do is respond or talk to women journalists who often face really horrible online harassment, bullying, doxing, stuff that's happening online that's putting their mental health at risk, that's making it difficult for them to exist in spaces where they need to be to do their jobs, but also sometimes correlates with offline violence. Now, acknowledging this, I want to point out a huge hypocrisy that we've seen when it comes to the enactment and enforcement of policy around issues of harassment and bullying online. Because we have a cyber harassment section of this law that is so broadly written that it's difficult to sort of raise a focus on things that are actually causing harm to people, and that actually the people who are enforcing it seem to be more concerned about the well-being of male rich politicians. So, and just, thinking about the region, more concerned about you've harassed a president or his family, as opposed to vulnerable individuals whose lives and, well-being and their ability to do their jobs and their mental health has been put at risk. So it's usually tricky sitting there to appeal to how do you appeal to law enforcement to use the same laws which tomorrow could be used to restrict that journalist freedom of speech, for instance. And if we even talk about wrongful distribution of, for instance, intimate images, there's a lot of talk about it, but when we look at these cyber laws, when they're enacted, it's mostly about let's protect the politician, let's protect the powerful people. So for me, that's the hypocrisy of the thing, like the rhetoric, but when you enact the laws, it's never about the truly vulnerable people, and it's never really about protecting them. Yeah.
This is a tangent. I'm so sorry. We're here to discuss PLCA. Yeah. No, you just made me remember some. So I'm just from training police officers in Homa Bay and Kisumu last week on specifically technology-facilitated gender-based violence, but also computer misuse and cybercrimes. Just the entire landscape. And what really caught my attention was before, I was giving this illustration of, do you know women in Grok have been, they've been undressing women across Africa. And the expression was so blank. So I went back and said, how many of you use Grok? Only like a quarter. How many of you know Grok? Less than half. So these are the very people that we are supposed to go and report. In fact, because we selected officers who man gender desks in every police station in Homa Bay and Kisumu. So they are the front-facing. In fact, they are the first point of contact for technology-facilitated gender-based violence. They do not even know these platforms. So you can imagine going to report and saying, my rights have been violated or my image has been undressed, and you expect them to do something. So the gap here is, more often than not, the gap I'm identifying is, okay, so laws are made in parliament by members of parliament. Cascading that to people who are supposed to enforce, we hardly ever talk to police officers. I mean, a lot of us interact with them in the streets when we are protesting. But that understanding, so for them to even understand that technology-facilitated gender-based violence is a serious issue, and once it is reported to them, for them to also understand that, at least establish pathways and mechanisms. We are so far in this country, very, 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 very far, just to buttress the point she was making. But back to computer misuse.
I think I'll ask Ochel to cover this because you've been in this process for such a long time, and you're heading towards the elections. And we have our fears because we know the kind of government we're dealing with. So you can guide us on, first of all, if you're going to
the Supreme Court, how long might it take? Is it another 8 years? So we know in the next 2 years, tutajipanga kiasi gani? But then how do we balance the digital regulation, our constitutional freedoms, public interest, plus political interest? I don't want us to talk about political interest, but they will actually, they will feature anyway, because it must be a politician, whether you're in your home, unasema MCA hajafanya hii na hii na hii, they can say it's harassment. And you're trying to just educate your villagers about like civic education or something. So first, how long do you think the Supreme Court will take? When are you filing? How long do you think it will take? But then for next year, how do we as Kenyans prepare for next year with these laws still hanging?
These days, being in private practice, I start to think about those issues when I'm instructed. When I was at Katiba, I'd think of them, proactively. Evika nacheka. But I think that there's room to go to the Supreme Court. I agree with Beatrice on that. I think I spoke before she came. She says that we need to go after these 24 sections. I think that we need to go after the least possible number of sections possible. Because having been to the Supreme Court a number of times, nearly 50 times, it's a political court. That's a reality we need to live with. Any country's Supreme Court will be a political court. So it's not the court that will give you 24 sections. It's never done that. Remember the 23 laws case? It didn't find one. I didn't find one. Parliamentary Service Commission. That was a process challenge to this same act. The one filed by the Senate saying they're not been involved. 23 laws. None of them came back from the Supreme Court that it's been nullified. So it's not the kind of court that will give you 24 sections of an act as critical as this one. So the least number, we can target the ones that interfere with the freedom of expression and maybe argue about one or two others, privacy, and see if there can be limits there. So it must be strategic litigation. There must be a strategy. And it must be a strategy that wins, because if we don't win, I'm saying the community thinking of going to court, if we don't win, you come back with a loss stamped by the Supreme Court seal. It's a permanent loss that will bite everyone on their backs. So there must be a very carefully thought strategy. You must only go with what's necessary and what you think you will win. Because if you don't, then you come back with that permanent loss from the Supreme Court. The Supreme Court does not reverse itself. But if you leave it at the Court of Appeal, then maybe in another day, there would be an opportunity to take another issue from that Court of Appeal decision to the Supreme Court. So go only with what you must go with, craft it narrow. At the Court of Appeal, I said we went with 48 grounds, and the Court of Appeal itself noted that paragraph 2, the first thing it said was, hey, you need to keep it narrow, and it reduced them to 6. So we can reduce to 3. Those 6 filter the 3 most important, or the single most important section to the stakeholders, and then go forward with that. The other issues around strategy, which I think maybe might not be appropriate for here, could be discussed within a smaller group setting. My other question is about the balance. There's something the Court of Appeal says which is important. I mean, there's need to balance, because you also can't have a free for all. And that balance is in Article 24. Is the limitation lawful? Meaning, is it vague? Does it only target the prescribed conduct, or is it a section that can be abused? Is it legitimate? There's legitimacy in controlling things like hate speech or incitement to violence. There's also a legitimate objective in protecting reputations. But then there's a third test, which is is a measure taken towards that legitimate aim the least restrictive? Are there other alternatives like the NCIC, which I think does not even go after politicians? It's the politicians, I mean, violate for example, the Hate Speech Act, but none of them has ever been caught ever. I've always wondered why. But that's the balance. There must be a balance. There can't be a free for all, but at the same time, the limits placed should not unduly interfere with the right as to take it away. So that would be my take. About the timelines, the Supreme Court hears its cases within a year. I said if you file now, you can expect to be heard around October or November, or at the latest next year around January. Then it takes another 2 to 3 months to give its decisions. So you could expect a decision by around April next year. If you had in October, you could have your decision by December or January. Thank you.
Thank you. I think I forgot to mention this session is being recorded. So if you don't want to appear in the video, just lift up your hand so the videographer will skip you. Nani amesema ako South Africa?
I can wait for them to videograph me and I go to her to get me a file.
Okay. I don't know if our speaker is well rested because we want to ambush this, but because we know how this case has been for the last 8 years. So I think you'll introduce yourself and give us your thoughts.
Oh, yeah. First of all, yes, let's just say that I'm happy to be here. My name is Dimas Kiprono. Also sort of a public interest litigator, human rights advocate, and with regard to the Computer Misuse and Cybercrimes Act, I believe, so almost a decade ago, I used to work for Article 19. And at Article 19, we were part of the committee that drafted the Computer Misuse and Cybercrimes Act. By that time, it was called the Cybercrimes Act. And at some point, when this document usually goes to the NIS and the security side of things, we also saw the misuse part being introduced. So initially, this law was supposed to regulate, hacking, safeguard critical infrastructure, and it morphed into a document that was policing speech, which normally that should not be. But even before that, we had seen a similar provision being passed in Ethiopia. And soon after, Kenya, Uganda, and Tanzania adopted the same language, where instead of policing or instead of regulating computer systems, unlawful access and so on and so forth, it was now regulating what is false, what is true, and we had a problem with that. And that is why we joined BAKE when the law was passed, to challenge the provisions. In hindsight, I think we might have been better off choosing the provisions carefully, because it was a blanket challenge to the law. Initially, we succeeded in getting almost all sections suspended. But come 2020, Justice Macau found that the law was perfect. And now comes the repression that we've seen in the years since, and increased during the times of protest. Generally, in freedom of expression, and especially when we talk about issues of incitement to violence and hate speech, there's a guideline called the Rabat Plan of Action, which says, look at the person speaking. Is he a leader? What is the speech targeted towards? But in Kenya, it seems like we do not apply that when we are conflating speech to offend national security or hate speech and so on and so forth. And so, as Dudley has said, we find that speech provisions are designed for the small person, for that lonely person commenting online or sending someone a direct message. However, our leaders can stand on the podium and call a whole community X. And I've said this because it's true that, for example, if you take the late Raila, the current president and the former president, and the way they used to speak about each other, one telling the other that unavuta bangi na unaiba kila kitu, the other one saying to the other wewe mchawi, that speech, if you are the ones if you are the one who speaks against, for example, the president, the Subarus will come, but they can do it. And so perhaps we also need to creatively look at how we can infuse these principles into our judiciary so that they can guide the parliament when they're passing laws. But it has been a long journey, and I believe that section 27, which is even more egregious than the others, needs to go. And perhaps it's a time for us to put our heads together and put in a strong Supreme Court guided missile application petition. And yeah, but part of the success that we've seen in court is also about advocacy. It's also about speaking about these things, writing about them in the media, so that the judges and the community knows that certain laws are very egregious. But I'm proud to be associated with the Bloggers Association of Kenya, Mercy Mutemi, Dudley, the other lawyers, Wamadhai, in seeing through this law that now at least defamation is dead. We fought defamation in 2017, got a very nice judgment by Justice, just forgotten the name. And the following year, the Computer Misuse and Cybercrimes Act, through Section 23, reintroduces defamation and makes it even more egregious in terms of you can find yourself in jail for 10 years for speech, So thank you very much, and I'm still here. We can continue discussing. At another point, we'll discuss the amendments, right? The computer misuse amendments. Yeah.
I think we can discuss it now, so we open it up to questions also on the amendment. Maybe will it take long I open the questions?
Let me just look at my notes, kidogo, then. Yeah.
Okay, so I want to open up to, I've seen some questions, some hands raised. So I think yeah, go ahead.
Okay, maybe just to add to what the gentleman has just said. In international relations, it's called the Speech Act theory, whereby if I stand up and say, I hate Maasais, nobody will really think about it. But if a senior government official or community leader stands up and says that I hate Maasais, the reaction from the people listening to it is to automatically act in a manner likely to suggest that they hate Maasais. So in IR, it's called the Speech Act, which we see being violated every other day by leaders in the community, where they just speak however and say whatever without considering the people listening to them. Thank you.
There's a question there. If you have a question, please raise your hand, and then we'll now. Yeah, there. No, there's the gentleman there, and then you'll take the microphone next. Thank you.
Hello, Barieno, Sau Makbul. So the reason I'm asking a question, I saw Dimas and then I was triggered. I think he's the right person to speak about this. So my name is Shukri Wachu. I am the Missing Voices Coordinator. So we are a coalition of about 20 organizations, including ICJ, that fight or strive to end police killings and extrajudicial killing and enforce disappearances and extrajudicial killings. Interestingly, in this judgment, when you look at in the past how it criminalized section 22 and 23, criminalized police liked to use the sharing or publication of false information to get people. Now the challenge with that, you saw a lot of people, particularly during protests or any environment where there is police presence. People, because of that act, feared sharing information in fear of retaliation. There was that legal risk of speaking out. Dimas, if I'm not wrong, I believe now that although it will still be there to a certain extent, there is a bit of freedom to how people can now share information, particularly citizen journalism, documenting instances of police abuses, and now sharing it and now forming part of the fight against police brutality. I just wanted you to speak on that, Matt. Thanks.
You have the, okay. Yes. No. It's open now to everyone. If you have a comment or a question, based on the discussion we've had and the question that I put it out there on the elections and how you feel with this law still hanging. But also if you have a question towards a particular speaker who's spoken this afternoon, the floor is open. What people say first. Mike. Okay. Is there anyone else?
I'm saying, sorry, what I'm saying is there's something very particular she said about how do people feel going into 2027 elections. I would really love to hear people speak. I mean, this is not Twitter, there's no Subaru. I hope that is going to come here. So, yeah, I'd really love to.
Okay.
Yeah, because I have my feeling. Okay.
Maybe you can start with your feelings as the others.
No. Okay. I want to hear others.
He wants to hear. So, anyone who has a comment on that, so he can talk to us. Anyone, even if it's like 100% confident you're going to the elections and these laws will not affect anything, that is still a feeling. If you're a bit scared, if you're happy, it's still a feeling. Just 2 or 3 comments on how we feel about it, because you also need to know moving forward what are the kind of systems ICJ and the team have put in place to support some of us to Takujua and Subaru just because of tweeting. You know, we need to do like step 1, 2, 3. What will happen? Yeah. So I think I've seen someone with the microphone. Okay, go ahead.
Oh, Viva, comrades, Viva. This is where I was waiting. For me, my feeling is that first I'm scared. I already have a worst experience of it already because my Twitter was suspended last week due to some posts I did. So for me, why I'm scared is that not only do we need to vote, but also we need to protect and guide our votes throughout the process. We also have this tendency of tuna vote and then we have 2 minutes where stima inapoteanga. Alafu hata kama walikuwa wameachana na 100 votes, tunaona tena wameachana sijui na million votes. So I'm also scared for another thing as an activist because I am mobilizing, I'm organizing in the community. And also, kuna hii limit of freedom of expression. Even when you post, there is a language whereby you are not expected to speak or to alter or to even use in your social media. You find even in social media pages, like in my TikTok, I have some videos without voice. Unaona? If the song is about the system, it's also condemning about any injustice happening. You find that everything is also against you, even the whole social media. Even some people are asking you, how are you even surviving? You're talking about this thing and you're still living. Like it's also a threat. My question is, how do we protect ourselves, our organizers, and every and each person during this period that we're working towards the election? We know how it comes for social media, kuangushwa kwa social media, which ishaanza na mimi, social media accounts, and also our freedom to speak, because I think from the previous elections that we have had, it's not as much moto kama hii this time, because everyone feels like I need to speak. You know, everyone now says like, now this is my point of view and this is how I see our system from previous years to these years. This is how the regimes have been wanatuongoza, and this is how I feel this time I'm going to make my change. And now because I want to make my vote, my change, I also have to speak from my media, social medias that I have, or the necessary places that I will be. But you find that the only freedom of speech that you're going to have, it's in a place like this. This is where I have the freedom to condemn and talk everything I want. But outside these doors, I'm afraid that Subaru might pass. I'm also afraid of the person I'm seated to. Because at times tumejipata hata maandamano, unaandamana na civilian hapo, kidogo anakuambia sijui nini, tunaendelea kuandamana, kidogo kidogo yeye ndo anakubeba. You know, you don't know. So how is it going to work for us that we are organizing through our social medias? Because social media is the only place whereby almost kila mtu ako addicted to the phone, where you can cut across a lot of people to get the information that you want without being bila kufungiwa ama bila kushikwa ama bila kupotezwa ama injustice yoyote kukufanyikia wewe mwenyewe kama mwananchi toward this time that you are heading, because it's already begun.
Thank you. Someone else with a comment?
I'll be very brief, by the way.
2 minutes, and then we have one last speaker, and then we get the answers.
Thank you. Actually, I love that conversation. I love the way the conversation is headed because I'm a politician. It is coded in every strand of my DNA, and I'm an aspirant, so I feel like this is my avenue. Firstly, I just would want to say that you cannot hijack a revolution. A revolution is birthed by blood, and we saw what happened during the 2024 June election, and I was at the front line. I mean, that was the first day I saw celebrities with my own eyes. People that I've never even gotten a chance to interact with. They were right there, and I mean, it was a moment that it was a bit scary, because I mean, I received thousands of calls from my mom because she would see me in the TV and she kept on calling me. But what I would just want to say, as we head to this very critical season, and the political temperatures are rising, and people are actually they are still bringing on this idea that, you know, there's this motto of makaratasi, we are just championing for this, but you'll end up being silenced, you know. Yeah, but what I would just want to say on that is, let us not retreat. Let us just come out in numbers. Let us just, air our opinions. Let us just articulate that which we think is right, and let us also be mindful, just like I said before, because we don't want it to turn into TFGBV. I mean, let us express, but express respectively, but also let us come out in numbers and vote in, and let us not be afraid, let us not be scared. Because, okay, I know there's always that fear that nitakujua and all that. Na ni mbaya sana, by the way, because utakujua peke yako na mbuki yako itaachwa hapo. So sometimes it's good that you support one another, and that which we post, if, I mean, we are mindful, then we are going to remove this.
Thank you.
Sorry, I don't need to lose it at a meeting like this, but what do you mean be mindful? Okay, it is very obvious. If today the Auditor General says that 50 billion Kenyan shillings has been stolen or has been lost, it cannot be accounted for, and then I go and I say, or I report that fact, what are you telling me to be? And this is what will get me abducted. What do you mean by being mindful? Wakili, what does she mean by because what is freedom if it is not me adding on to the conversation of 50 billion shillings that the Auditor General, this is a fact. The Auditor General does not gossip. You understand? So you cannot limit my freedom by telling me to be mindful is what they tell you in State House.
So I think.
When we're talking about TFGBV, because I mean, TFGBV is tech facilitated gender-based violence, and that does not mean that is not even the political domain. That is not, no,
that's different.
Pinpointing and challenging the status quo is not part of being mindful. I mean, what is the point? Are you getting what I'm saying?
So, no, we are talking about two different things. We understand that you're talking about gender-based violence. So
and it can also
on
be
how we talk about it.
correct.
Yes, he's talking about elections. So those are two different things, and that's why I wanted us to talk about balance. And Oduro, I think, will take us through that, the balance between those two things that you're talking about. So for just 1 minute, he will. Yes. Yes. So let's hear from him, because we're talking about two different things, but.
Yes, I think we are talking about elections, right? Huh? And I think for me, exactly from what I'm seeing here is that we are repeating the same mistakes, huh? Because we are talking, yet the people we want to remove from power are planning and organizing their numbers. Huh? So to me, I think as people who want good governance, first of all, let us get the basics right. And anytime I get this conversation, I ask a very simple question. If we were to vote in the next 1 hour, how many of us are eligible to vote? Let us just do that. Yes. Yeah, if we were to vote in the next 1 hour, how many of us are eligible to vote? Yeah, that is good. So I think that's what we need to do is that, first of all, let us get the numbers. If you've got the followings on social media, use the social media right now first, just to encourage people who are 18 years and above, first of all, to get ID. Once they have the IDs, I know in 2 weeks, IBC is going to launch mass voter registration, I think on 30th. We are going to have, like the media, we are going to have a pre-conference with them on 27th, during which we are also going to renew how the media is going to engage with IBC in terms of election reporting. And what we are discussing on our side, which I will also want to hear from you, and what we are discussing, is it possible for this time around the media to call elections? Is it possible? That's the question that everybody is asking us. That when we vote on, it will be on 10th of August, on 11th, very early in the morning, can we have the results out? Because that is the only way we can help this country. And the conversation around the table is that we will have different organized group announcing their results. I am sure political parties will organize themselves to have different results, especially the social media. IBC will have their own results, and different groups will have results. Then what will happen? It will be totally chaotic. So that's why we need to organize ourselves and find a way how mobilize the numbers and have the systems to check that the votes are not rigged, all the way from the polling station. There are about 46,000 polling stations. Can we organize the numbers we have? Because for us, when we were challenged, we say that we do not have 46,000 journalists in Kenya to be at every polling station so that they can help us. But I'm sure with our network that we have, we can mobilize 46,000 people to be at every polling station, so that we be the watchdog at the polling station, so that when IBC tells us that, for example, at Kilimani Primary School at polling station, candidate A got 9 votes, yet the candidate got 900 votes, we already have somebody in the ground who will say, no, I was there, and here is the picture of Form 34A. That candidate actually did not get 9 votes. This person got 900 votes. That is how we'll help this country. So let us use the numbers we have on social media to mobilize, first of all. Let everybody be eligible to vote, anybody who is 18 years and above. Then from there, let us now form groups on how we can be the watchdog at the polling station, so that the vote is not rigged. I can tell you for free, I don't have the confidence on the commission we have right now. All of them are green. IBC, if you look at the way it's constituted, everybody is new there. majority of directors and managers left the organization. It means that people who are taking over those positions are new people. So we are going to have again the new commissioners and the new technical staff who are new. So that calls us our civil duty as Kenyans. First of all, just get the basics right. That's what I'll say for now. Let us get the basics right. Let us get the numbers. Once you get the numbers, when that time comes, then you'll be able to organize when you have the numbers, because politics is all about numbers. So that's what I'll say for now.
So allow me to bring the conversation back to cybercrimes. We have our last speaker. She will tell us her name, why she was late. She's the advocate of the High Court of Kenya. She's also a digital rights and policy programs officer at Article 19. So you can tell us your view on this quickly before now we need to get comments from everyone, and then questions directed to you will be answered later. Thank you.
Thank you. I got late because I was held up in another meeting that went a bit over time. But thank you for the opportunity. As introduced, my name is Angela Minayo. I work at Article 19 Eastern Africa. I lead the work on digital rights and policy. This was a case that we were very interested in because of the ramifications it has on digital rights. After Jacqueline Okuta, we thought, that's the end of criminal defamation. Those who are not aware of the facts for Jacqueline Okuta, you'd be interested that someone posted something on the Buyer Be Aware Facebook page. And then the person they were talking about felt defamed. And he charged Jacqueline Okuta under the Kenya Information Communication Act. The section that was used is very much similar to Section 22 and 23 in the sense that it was criminalizing publication of false information. And Article 19's position is that, look, we understand defamation as a remedy, but let it stay as a civil matter, not a criminal matter. The moment defamation crosses over to become a criminal matter, then it has a chilling effect on free speech. Because not only are you going to be, pay some, in a civil defamation suit, you might pay, you might even prove it was true or not, things like that. But if it's a criminal matter, then you're facing prison term. That changes it altogether. You can use criminal defamation provisions to make human rights defenders not talk and things like that. So when Section 22 and 23 came up in the Computer Misuse and Cybercrimes Act, it was very much a reminiscent of, this is Kika again, right? And so as seeing and reading through the judgment of the court, as much as we didn't get several other provisions to be held unconstitutional, I think all digital rights activists in this room know what Jacqueline Okuta did for the Kenyan freedom of expression space and what this judgment is going to do now. As late as 2024, we were already having cases under Section 22 and 23 by public officers against protesters. Yes? Oh, you're one of them, exactly. And so when we talk about the chilling effect of such criminal provisions, it's not abstract. These are real life of people being affected. And the other concern we have around criminal defamation is that legislating truth or having a duty of truth is a very slippery path. Because for people to know the truth, we must have diverse media, we must have access to information and all these things, sometimes which we don't have. So you cannot have this legal duty of truth being codified and even having a criminal case or a criminal charge out of it. So it is really a win for Kenya's democratic space. And even as we go to the 2027 elections, I think the courts have spoken. In a very wordy, lengthy judgment, they have said that Kenyans can speak freely. Thank you.
Thank you. I think we'll give Dismas a few minutes to speak about the amendments.
Yes, first of all, I'd like to recognize the presence of the President of the Kenya Union of Journalists, Eric Odwar, and Angie. whom we've worked with on these issues. So I believe what Angie was saying is very relevant, because Section 22 was dealing with the Geoffrey Andare case on Section 29 of the Kenya Information and Communications Act, which was talking about misuse of a licensed telecommunication device. And 23 was dealing with the Jacqueline Okuta case, criminal defamation, which is Section 194 of the Penal Code. And so Article 19 goes to court, wins these cases, and the following year, the cases are snuck back in the Computer Misuse and Cybercrimes Act, which should actually be, it shows bad faith. Yeah. And now part of this struggle is that last year, we also got more amendments to the to the Computer Misuse and Cybercrimes Act. So the first one attempts to give the Cybercrimes Coordination Committee, which is a body comprised of a representative from the Office of the Data Protection Commissioner, NIS, the Communications Authority, even if you look at the composition, it's supposed to be a technical body to safeguard our critical digital infrastructure, not issues of speech. But in any case, the amendment attempts to give this body the power to render any website inaccessible because of publishing cultish terrorism, it talks about cultish content, terrorism content, things that annoy, very vague provisions. And that is very dangerous, because in actual sense, it is trying to justify internet shutdowns. And so the same bodies here moved to court to challenge that provision. First of all, because it is vague, and second of all, it gives this body powers that should have judicial oversight. Before any website is rendered unusable, someone should go to court and get an order. The second one is an extension to Section 27 that amends the Section 27 by criminalizing content that is likely to cause someone to commit suicide. Also very vague. And also, someone might be actually in the verge of committing suicide, and you tell them something, and then they do it. It's also quite vague. It's neither here nor there. And in fact, we have spoken to people in the mental health space to help us formulate our argument to the court. Because on the face of it, someone might say, "Oh, you want people to kill themselves, or you want people to harass themselves to the point of suicide." But that's not the point. The point is it will catch people who are innocent. And that is the whole point about these vague provisions, the problem about vague provisions. And the courts have had the petitioners and all people supporting the petitioners. And now we are in the side of the respondents. And I believe in this one we'll also get a decision sooner than later. So it is in the last parts of this case. Thank you. Oh, yes, there was a question by Shukri, a comment. Actually, part of the reason that the Court of Appeal picked up this case and ran with it last year is why? It is because of what happened to Albert Ojwang. This case was sitting in court from 2020, nothing moving. We had appealed. And so when that happened, and we also wrote letters, the court was seized with the matter and decided to deal with it urgently. And so Section 22 and 23 were being used to shelter leaders from criticism, to criminalize members of the public from being able to criticize their government, yet we are the sovereign. And if you read a case called Robert Alai versus the Republic, which was also done by Article 19, in that case, Justice Muita, who has now been elevated to the Court of Appeal, was doing a decision whereby Robert Alai had commented about something that Uhuru said about something that Raila said. So politicians are talking, then Robert Alai comes in. Then he was arrested for undermining authority of a public officer. That was section 132 of the Penal Code. And when we went to court, first of all, we said that any person should be able to speak about their leaders. And the courts agreed. Yet, what was manifesting on section 22 and 23 was exactly against that. All right, thank you.
Thank you so much. We have 20 minutes, exactly 20 minutes. So this is what I would want us to do. Questions and comments that are under 1 minute. You can just raise up your hand. And I had a question. I think we have a lot of legal experts. As you think about your question, let me throw this to the legal experts, right? My issue is usually now the election as we head there. With our digital spaces, our social media spaces, our blogs, our vlogs, my concern is, of course, the laws will be used against us. How do we fact check? What are the advice that you would give a young person? And I know you receive a lot of requests for help. That, oh, I tweeted this, I reposted this, oh, I laughed at this, but I've been arrested or something has happened to me. How do you help this young person know the process of like fact checking? What are the things that they should keep in mind as they're posting? Because we're excited, we want to post. Probably it is AI, probably it is a rumor, someone said, who said this. So how do you protect these young people? Because I know at some point we'll be overwhelmed with 1,000 young people in cells. So what are your last words as the legal minds on how a young person can use their social media, your borderline, the laws, but also be able to have the freedom of speech? As we get at the questions, I've not seen any hands, so, oh, there is a hand there. I want 3 hands or 4 hands. Questions under 1 minute. So any legal mind that would want to take that, 1 or 2? Chair, okay.
Just ask a question.
I wanted to say it's not more of a legal question per se. It borders around social media hygiene, and I think the chairman would be the best to answer that, and also clarify on what misinformation, malinformation, and disinformation is. Yes.
Okay. Any question? Watu wa nyuma sijaona question. We want to take at least 3 before the speakers answer. There's another hand here. The last hand. Okay, I think then we'll take those 2, and then we'll give chair to answer.
My question is, who does the mainstream media work for? Because we have seen in the past a few times it has failed us. We also saw during the Gen Z election, also what happens with the mainstream media. We also saw Safaricom inatupotezea network tukiwa kwa maandamano tunaamua kutumia Airtel. So my question is, who does the mainstream media work for?
So thank you. Okay. So my question is about media airtime. I'm very privileged to sit next to you. You are the Kenya Union of Journalists Chair. So my question is, what protocols will the media use? Will we see some candidates, like for example in Citizen, you see a particular candidate is leading And when you look at another station, like maybe KBC, someone else is leading. So what protocols will be used to make sure there will be fair media airtime? Thank you.
Okay, let me start with the last one, so that I don't forget it. What we are trying to address right now is that is there a way we can have a common portal for all the media houses, so that if all the media houses are reporting results, be it Citizen, they should be reporting results from the same number of constituencies and the same constituencies. Because what happens is, you'll find that maybe we have got 290 constituencies, let's put it that way. So Citizen maybe could have a different results because they are announcing results from 200 constituencies. KBC is maybe usually behind announcing results from 100 constituencies. KTN maybe in between is announcing results from 180 constituencies. NTV maybe from 170 constituencies. So you see, those results cannot be the same. So the protocol we are setting right now, is there a way we can make sure that all these stations are running results from similar constituencies, the same number of constituencies, and all of them we pool so that we have a joint tallying system? So that what you see at Citizen is the same at NTV, the same at KTN, from the same constituencies, from the same polling station, so that there is no discrepancy. Because that's what happens. So that is what we are working on this time around, that come next year, when this is happening, we have a joint tallying system from which every media house is picking the results from. And also to make it fast. That's what I was saying, that is it possible that we can make it fast, that by morning on 11th of August, we have the results from 290 constituencies, all of them, so that the media houses are reporting from the same. So that is what we are working out. The problem is the logistics. If it's possible, it will happen. So that's what we are working at. Then the second question from my sister there is no difference between social media or mainstream media. Media is a platform. Be it a conventional media, what we say maybe like NTV, Citizen, what you are saying, is a platform, because it's the same media houses that are on the social media. If you go on Facebook, you'll get Citizen is there. If you go on X, you'll find KTN is on X. So media is just a platform. So there is nothing like mainstream media and social media. I think there is something, that confusion people try to create it. All of them are just platform. So, and the media serve the interest of the society. So the media does not work for anybody other than the society. That's what I know from where I sit, that our interest is to serve the best interest of the society. The problem is the society has got different interests at some point. You as an individual, maybe you've got interest. You want to see your candidate leading. If your candidate is not leading, then that media is not serving the society. That is the problem we have as Kenyans. Then there's a question about the information disorder. Disinformation, misinformation, and malinformation. Disinformation is intended where you are misleading people knowingly, that I'm going to say A, B, C, D about so and so, and I know that I'm lying. That is disinformation. Misinformation is when you are conveying a wrong information unknowingly. So there is no intention, unlike disinformation when there is intention. Malinformation, you are also relaying correct information, but also intended to injure the reputation of a person. For example, I know I've got an access to your pay slip. It is your pay slip. It's so factual that is your pay slip, but I'm going to put it out there. Do I have to put your pay slip out there? No, because I want to expose you. So that is what malinformation is all about. The information could be correct, but again, I'm using in the malicious way to malign you or for to achieve a specific agenda. So that is the difference between the three. What are we trying to do? I know, and again, as the media we've discussed this, we know we are going to have so many of such, especially disinformation and misinformation using social media platform. Like I said earlier, we will be said that, oh, so-and-so has been arrested, and therefore, just for the purposes of inciting the supporter of a politician. Or, like I said, we will be having different tallying systems whereby you are giving wrong results for the purposes of achieving what you want. So what we are trying to do is that we will try to develop fact-checking tools to be available for anyone. So if you've seen information and you are not quite sure whether this information is accurate or not, you can use that tool to fact-check whether that information is correct. Even the pictures, because we all know right now, actually, our nightmare is AI. AI can do anything, can even generate your own voice. and you'll be out there that I've stepped down, I'm not going to vie as a politician for a political seat. You see, so those things are going to happen. So we'll need to have a fact-checking tool that can be used to check whether that information is accurate or not. So we are much aware of what is going to happen in when we are coming to elections next year. A lot will happen, but as a society, we've got that responsibility to ensure that things go the right way. Thank you.
I can see two hands. I'll give them a minute, because the lawyer who made everything happen is in the house. So a minute of your comments or questions.
I also want to add on to the misinformation, disinformation part. When I was introducing myself, I was not particularly representing Africa Check because we don't usually participate in policy discussions to maintain our independence. However, I think there is very simple ways to make sure that you're sharing factual information. Right now, a lot of us are monitoring the situation in Iran, in Dubai, in the Middle East. And the number of times when I'm scrolling my timeline and I see breaking, and it's the Prime Minister of Israel has been killed. And I'm like, okay, firstly, who are you, some John Doe, who's reporting that, such big news? Everyone right now is writing breaking. And that will be what will be happening during the elections. So imagine that type of information is going to be rolling down your timeline throughout, and it all looks very exciting. You want to also be the primary source of information. There are people who are actually being paid by these same politicians. So we have to take a next step forward. Even something as simple as going to Google and checking that is the Prime Minister of Israel dead. Last reports about Netanyahu was 24 hours ago. I mean, it's very simple, but usually people don't want to do that. Other than that, Africa Check in Kenya is definitely going to be doing a lot of debunking and also pre-bunking. I would also advise you, because channels like Twitter, WhatsApp, and Facebook are full of disinformation and misinformation, switch on your TV. This is the time now we are going back to switching on our TVs to actually make sure that the images that we are seeing are actually legitimate. The other day, I was seeing a picture of this. There's a big explosion. Apparently, some oil tanks were being exploded in Iran. And at first, I was like, nah, this is disinformation. But then I switched on Al Jazeera, and it was real. So right now, everything could be real. It could be it could be fake or real. And right now, the world seems like it's a simulation. So doubt yourself even. And look for a more verified information source. So you may not trust the media entirely, but I think they are better source of information than John Doe on Twitter.
Okay. Yes. Thank you. I think she has a question, and then Mabel.
I think I'll need some clarification on this, but I remember like the last time we were doing, there's an election amendment bill 2024, and it wanted to remove the live streaming aspect from media houses. So in as much as we want the live streaming we want to practice some accountability for this, we first have to participate in these processes of participation and everything, so that these laws cannot actually be put into the act. I remember they were trying to remove the law as it is right now is that IEBC live streams the results, and then the media houses get from IEBC. But then they want to remove in the amendment bill, they want to remove the live streaming aspect so that they can just count the votes and then put it on their website, and then for media houses to process to get from that. So yeah, we need also to pay attention to that. I really don't know if the amendment was removed, but that was how it was the last time.
Thank you. Okay, 2 minutes, and then we give.
No, I just need one. I just need 1 minute. So, with regards to your question on who owns the media, what did you ask? The question was? Interest serve, something like that. Yeah. So basically, I disagree with her about watching TV to confirm whether it's real or fake, because our TV is full of a lot of propaganda, highly packaged, well. Yeah. It's cow dung packaged nicely. It looks like a very nice cake. But and a very simple example I'll give you is Nation Media Group being sold off to a Tanzanian billionaire. We all know who that billionaire is. The only reason why they are buying the media house is to control what you are going to watch on media. And another example is I remember just before the Adani deal in 2024, and then this man, Chirchir Davis, he was on a media house, and that interview was so terrible as a whitewash. Like, and that's the first time I had watched TV in a very long time. I lost my mind because that, and the journalist is a very respected guy. The questions he's asking him, it's like, you know, kalongolongo when you're playing around with children, to something like that. So it's all about interests and who owns it. There's something else regards to election tallying. In 2022, I remember there were two different citizen-led Form 34A counts. I don't know if E.A. Kwame, I think one of them, he was one of them. And that tally was, their tallies matched IEBC by a difference of maybe 5-10 votes. So a centralized tally is highly possible. There's nothing complicated about it as long as that Form 34A is on the IEBC portal and that Form 34A is real, because what we are going to fight into 2027 is there's a lot of planned vote theft. Like, we can see it, we can hear it. Like, if you are Kenyan, you look at these people speak, wanatuambia tu live, this is our gameplay, sawa, hivi ndio tutafanya. So this is real war. So my dear, yeah, it is real war.
We are running out of time. We need to give Mercy a chance to talk. She's the one who really made this happen. So briefly, okay, let's clap for her. Thank you.
I'd like to add into what he said. An observation in time ya maandamano, when things were heated on the streets, wenye tulikuwa home, we really wanted to see nini inafanyika kwa hii street. But all you could see ni watu wana dance yoga, and things are heated kwa street. If it is not watu wanaingia live, for sure hatungejua nini inafanyika. So I would really not agree that media is working for us, especially the mainstream media.
That was good under 1 minute. Thank you.
Hello, everyone. Let me start by apologizing for being super late. I really wanted to hear the reflections that came earlier, but I had Wamathai text me. Alafu amesema, so I sort of have an idea of the discussion. Before I introduce myself, let me just comment and say it's really refreshing to see that we are taking conversations about where we are at and using them to project where we are going and starting to think about elections. So I'm so glad that I walked into a conversation about elections, because we really need to constantly think about not just the now. We can't afford to be myopic. By way of introduction, my name is Mercy Mutemi. I'm the Executive Director at the Oversight Lab, and we focus on fair and equitable technology on the African continent. That's been my focus, is just how to shape a future that is ours. And as far as tech is concerned, how can this tech protect us? How can it advance our democracies? How can it build our countries instead of constantly being on the receiving end? 2018, I had the pleasure of receiving instructions from the Bloggers Association of Kenya to represent them in this case. I'll take maybe 2 minutes to just reflect on the journey and then just give my general observation of what the Court of Appeal judgment has taught us. I remember appearing before Justice Chacha Mwita the first day, and he was challenging us about every single section. We had challenged 26 sections because to date, I believe that there's so much that is problematic about the Computer Misuse and Cybercrimes Act. Now there's been an amendment. There's even more that is problematic about that. And with every subsequent amendment, there's going to be a problem because the foundation of that law is what is the problem. It's not just some wording, it's the foundational construction of that law. That's what's the issue. And, just running him through these provisions, he could see and he could understand. Actually, that makes a lot of sense. And for 2 years, he gave us conservatory orders that stopped the coming into force of the Computer Misuse and Cybercrimes Act. Now I look back at how we used those 2 years, and a learning for me is that litigators and civil society, sometimes I think we are always firefighting that we forget the saying for when you can't fish, fix your net. There's so much we could have done in those 2 years that I think was a missed opportunity, because when the case finally came up for hearing, we found a different judge. And I always like to give this statement to just alert you of where we are at in terms of digital literacy. It was Justice Macau, I think he's now retired, and he said to me, I want you to speak very slowly. I'm writing down everything you're saying because I don't understand what you're telling me. So I'll go back and I'll read your notes. And that's your stomach falls moment. So I just knew, okay, if you're not understanding what I'm saying while I speak orally, there's no amount of reading that can bring you up to the speed. Is it the age factor? I'd like to think not so, because I've met very elderly people who appreciate tech factors. Is it a digital literacy gap? Maybe. Is it a connectivity of the issues? For sure. But I reflect on that loss and think about this panic that the internet really arouses in the older generation especially, that when you see the internet working the way it's supposed to work, it actually shocks you too much and it instills fear, as opposed to, oh my God, can I engage with this and try and understand it? And the perfect example is the June protests. It's like, what do you mean you're shocked that people are communicating online and using online spaces to plan a protest? Why do you want to ban the platform? Because they are using the platform the way the platform was supposed to be used, So there's a panic that is both protectionist, that is from a very conservatory perspective, a lot of religious influences as well, but also that is driven by panic and not understanding these things. And now the journey to the Court of Appeal, again, many lessons to learn there around the inefficacies of our judicial system and how much they cost us. Like, there's an economic cost to those inefficiencies. If you think about the people who have fallen victim of just the 2 provisions on fake news, how many people have been harassed, how many people have actually left the profession of the information society in general because, oh my God, I'm being harassed, I need to, how many people have been forced into self-censorship? And self-censorship has such a deep impact in democratical conversations as well. And to think it's because of an administrative nightmare in the Court of Appeal that, like a bride, shows up when it wants to show up, but you have to wait for the bride because the wedding cannot continue without the bride, right? So there's lots of lessons there, but now coming to the judgment, and I encourage you to read it. One, because we're not angry enough, and I feel like as you read it, you'll continue getting more angry. So it's good to toy with your emotions a little bit, like to challenge how angry you can get. There's some things the Court of Appeal says that, will rub you off the wrong way. There's a pedantic exercise that they're doing of evaluating things where they state the principle and not really apply it, which is quite strange and almost like a watering down of Article 24. I found that to be the most shocking part for me, that for years we've looked at Article 24 as this immovable rock that we can always, the solid rock we can always rely on. And the Court of Appeal has somehow found a way to water it down a little bit. It's both sad, it's concerning, but it's lazy. in a sense. But that's not the legalese and what went wrong in the judgment and what could have gone better is not really what I want to focus on in this minutes. That is for Beck and the lawyers to sit down and figure out, okay, what else could we have gotten out of this judgment? Is there a possibility to go to the Supreme Court and advocate for more? My opinion definitely is yes, because there are some deep, deep problems that are not yet solved. I struggle so much to celebrate what the Court of Appeal has held with regards to the fake news offenses, because is it a win if so many people have fallen down by the road over these years? Are we celebrating, or are we dusting ourselves to bury those who've been hurt and to heal the ones who've been wounded? It feels like a miscarriage of justice that we fought for this many years just to get what we knew from the start was correct, that this was an nonsensical provision that was meant to harass people. And in fact, I read the judgment as like, this is literally what we said, the mirroring of the words, like in every TV appearance, every blog, every tweet, people were saying the same thing, that this is going to be used to abuse people. What do you think you've said, like after how many years later, when you say the exact same thing to invalidate it? Like, we have so much respect for the court, for upholding that provision, but at the same time, as a participant in the Kenyan discussion from a civil and democratic perspective, it feels like such a huge loss, so much time that we lost in that. At the same time, it reminds us that we can't give up. We have to, as long as there's space to advocate, we have to advocate. Now, to my main learning from that judgment, there is this thing that has now become very clear. We are not connecting the issues enough. We're not connecting the issues enough. I liked the debate about whether the media works for us or the media doesn't work for us, and like that. We are a very informed society, generally informed, but our information is very surface level. We are not deepening our understanding of issues. Let me explain what I mean by this with the example of the privacy provisions. From the start, I always said that Part 4 of the Cybercrimes Act was one of the biggest problems. What it is, for context, is the investigation procedures that prescribe how a police officer can access traffic data, can even mirror systems, telecommunication systems, to carry out investigations. So a lot of people have been wondering around the June protest, like how come, how did you know where this person was? And when that conversation was happening, I had this instinct of like, what do you mean? How did they know? There's a Computer Misuse and Cybercrimes Act that tells the police officer you can actually go straight to the telecommunication company and they can allow you to mirror their system for 6 months and you don't have to tell the person who's been surveilled. It's in the law, right? And we have complained for so long, Safaricom is a problem, the green up, and there's been so many campaigns to defeat Safaricom on one end. There's been a case about privacy going on another end, but we are not connecting the issues. So for a long time, it has been argued out as a Safaricom problem, that Safaricom is collaborating with the government, that Safaricom is doing this, is doing that. So we lost sight of the fundamentals of that problem, because it's not a Safaricom problem, because if Safaricom is doing it, all the other telecommunication companies are doing it, which could be worse, because think about the home connections, the fiber connections, right? And all these are things that are addressed in the law. But we get distracted in the highlights of the story that we forget to do some deepening work to understand the why. Penye mbiu lazima pawe na jambo. So of course, when people say that Safaricom is giving people our information, we should have believed them. Whether we had the evidence or not, we should have believed them and then deepened the research. But at the same time, the people of us who were in the case, from the start, we read that bill. We knew what Parliament was doing. We also had a responsibility to bridge the gap so that these conversations are not separate conversations. It's the same conversation. And let me tell you my thinking of how not doing the connecting work has come to cost us in this cybercrimes law. And I'm not saying that I'm absolving the judiciary from their role. They definitely have a role, but we would be stupid to not learn. We have a duty, a huge duty to learn constantly about how to do things better. As a civil society, as an information society, and as the Kenyan public. When you don't do the interconnectedness of the issues, parliamentary debates, which are captured in Hansards, become the only direction or the only truth teller that the judiciary is looking into. So if the Hansard records that this problem is bigger than it is, then the judiciary is saying, and this is what the Court of Appeal is telling us, we can only look at the Hansard. We can't look at anything else other than what was informing the legislator. There's a case they've quoted there that says that to understand the intent of Parliament is to look at the information that Parliament had at that time. And the way you figure that out is by reading the Hansard. If we don't do the deepening work and do a lot of publicity around it, we end up with very weak debates in Parliament. The debates that informed the Computer Misuse and Cybercrimes Bill, my God, they were very worrying. It was about, there's a liar that I cheated with somebody, now we need a fake news provision. Oh, there was this that happened, now we need another provision. That it was very basic level. You could tell that the citizenry and the parliamentarians were not on the same page. Our parliamentarians, we don't like them, our politicians, we don't like them, but we have to figure out a way to infiltrate the information ecosystems. It's not the information ecosystems. And firstly, they have information ecosystems. They have research departments that listen to specific people. And you have to know, for example, for the energy sector. The energy sector realized that the government doesn't quite get it. And what they did was hack Parliament. They stuffed Parliament with the people, they stuffed people, there were people who understood energy law, that the drugs that were coming out of Parliament actually reflected what the industry players were. It is a failure in this time, it is a private sector tactic, we have to learn from it. If you don't infiltrate those information ecosystems, whether it's the media, whether it's a different ecosystem, whether it's research, whether it's one-on-one engagements through workshops, you will end up with the exact same rudimentary discussions that gets embedded in Hansard records that you take to court and the court gets to say that this is the information that Parliament had. The other way that it can really cost us, not me us, in the legislation, not up to what the Constitution says. Then we're looking at the effect on society. Why? There isn't an effect to look at. Why do we look at fake news but not look at privacy? In fake news, they literally say what we've been saying for a long time. So that to me communicates that they are also active members of the public, they understand these issues, they have these conversations, and they know that the fake news one was a problem. But the good one that the tourism was connected in this way. So why would they be able to exercise other than what is required of them, which is like a legalistic analysis of it? So my invitation to all of us, and we have a role to play here, there's been enough time that has been spent in us falling for the divisive politics, and not from even political alignments, but from a capitalistic society. We are told, like, the media is this and this. We've done enough of that, and we've spent enough time doing that. Now it's about deepening and understanding things. Someone was talking about deep fakes, for example, and I'm concluding in a minute. He was talking about deep fakes. We've been talking for the last couple of months about deep fake pornography and how a lot of young people are being targeted with deep fake pornography, right? Here's an example of something that can be an interconnected issue. Deep fakes is also going to be our biggest headache in elections. Right? So you might not appreciate it from a tech-based gender violence and tech-affiliated gender-based violence perspective, but can you understand the relations perspective? And then what are you doing about it? What is the regulatory framework that we're pushing for? The thing that we've done was coming up with new cycles that he's young, we don't care about this one, is going to cost us. All these things, they're connected, they're related. So when we understand something, it's our role to convene these gatherings and do some deepening
work. Okay, but what else is this affecting? And then craft our advocacy around that. With that being said, kudos to the Bakers Association of Kenya for Bakers Association. You're baking, you're cooking. So the Bakers Association of Kenya for advocating for this and for bringing us along this journey of advocating for this. This will definitely go in the records that you stood for Kenyans when the space called for it. However, the journey has just started, so I hope you're not willing to give up anytime soon, and we are here to be your partners in the long haul. Thank you, everyone.
Can you do another big round of applause? Thank you so much for coming. We really appreciate the work that you've done over the years. I think now we have come to the close. We want to give Valerie a chance. There's another event happening in the next 30 minutes, so we should give her a vote of thanks. And then there's some writings on your way out, so you can grab something. Oh, we need to take pictures. So I think after Valerie, we'll take some pictures here. One big picture. Alafu we will have something to bite and head home. Thank you. Good afternoon, everyone. So I would like to say thank you for making the opportunity to come here. We really appreciate this book. In the case, we really thankful for the outcome. Initially, I think the book team, we are really sure we're actually expecting a lot of the case. We were prepared a case material in the same way. This has happened earlier, so it's okay. But we are very grateful. This isn't our way, but it's our way for all of us. And we still believe the time save the children's because within the same, clearly it approach the law is not the same way as the police are going to approach the law. So as remember that. And finally, I think I would just like to say I thank you for supporting us, especially for our legal team, ICJ, our lawyers in Kenya. You really pushed this, and we are very grateful. And as we finish, I think we'll have our photo session, and then we proceed to having some snacks and whatever else that is there, and then we can leave at our pleasure. My name is Valerie Muhammad, and the communication is not a big. Thank you.